I think we can start.
I think we should start. Yes, welcome back to our final session of our workshop on research agenda for the gig economy and society. Before we proceed with the three last papers, I would like to inform you that the session is recorded. If there are any objections, no objections. So we move on to our first paper by Professor Alan Bogg and Ricardo Buendia Esteban, a paper contribution that examines the role of the law in worker voice in the gig economy and specifically focuses on some normative approaches to worker voice that they are related to platform work. Alan or Ricardo, you have the floor.
Okay. Thank you very much, Harry, and thank you very much, everyone, for being here. I'll do most of the talking, but Alan, of course, you can chip in anytime you want. I'm going to share my screen now. That's okay. Did I do it right?
Is your camera on? I'm sorry, because, okay.
Yeah, I'm freeze now.
Okay, that's right.
Okay, can you see my screen now?
Perfect, yes, thank you so much.
Okay, fantastic. So yeah, as Harry was rightly saying, we're going to talk about our project that is, provisionally termed the law and worker voice in the platform economy. This is a more philosophical contribution, to put it in a way. And we start our argument of this contribution by saying that traditional justifications for labor law, such as, for example, democratic pluralism, have been, let's say, eroded in a way by the changes in the labor market and the detachment of labor law from institutional moorings. For example, the idea of, again, standard employment relationship and how, we are approaching new non-standard forms of work. In this process of change, there's also a lack, or we're losing political consensus for supporting labor law and collective labor law in general. So if there's, if societies are losing political consensus over whether labor law and collective labor law should be regulated one way or another, then the immediate question is, why should we still secure collective voice? And we think this is a very important question in the context of platform work, because it will help us to underpin why should we protect platform workers, looking for theoretical foundations of platform workers' voice, in other words. In our contribution, we contend that basically this change has been led by theoretical foundations of republicanism and theories of rights. And with this, we don't mean to say that republicanism and theories of rights are antagonists. Instead, we think that theories of rights have been very helpful to ground, for example, fundamental labor rights. But republicanism focuses on something which is broader, and it's a focus on power and a focus on structures. I will explain that now. So our aim is to provide a theoretical foundation for collective voice of platform workers, or as I said here, in other words, to kind of explain why we do what we do in collective labor law and why we should keep doing it. So I guess our initial question in the context of platform work and republicanism is, where do platform workers' problems come from? And we think that platform workers' problems come from a focus on power and domination, and how power and domination are setting structural and individual terms and conditions of work for platform workers. And this is important because platform companies, as we contend in our contribution, platform companies are capable of disrupting existing markets. For example, the taxi market has been heavily disrupted, right, by the emergence of platforms. And platform companies are also capable of creating new markets. And this poses challenges for these new markets and how to be regulated, if being regulated at all. There's also a problem with the norms, and we pay a lot of attention to the legal structure that supports labor law or relates to labor law. So, for example, there's a big problem in platform work with the contract of work. As we discussed yesterday, it seems some jurisdictions pay a lot of attention to the contract of work, whereas other jurisdictions tend to be more friendly to the problems of platform work and the contract of work. Also, for example, there's a problem with the binary divide between workers and self-employed. I'm sure we're all very familiar with the problems that the binary divide creates on platform workers being deemed workers or deemed self-employed undertakings. And there's also another set of big problems, which is relational problems. And this is related to dyadic forms of domination, something we just discussed. And it's based on how the platform can impose the conditions, right? There's a problem of conditions settings. And this is the scenario of focus on power and domination that, lead us to ask again, what is the problem and what do we propose? So in our contribution, we think again that there's a problem of power and domination in general in the labor market of platform work. So we propose three approaches, or we explored three approaches based on this Republican idea of power and domination. In examining these three Republican approaches, we talk about the first strategy, which is exit, the second strategy, constitutional rights, and the third one is radical models. We think, or we discuss each of these Republican strategies to overcome the problems of power and domination of platform workers. And, we talk about the first one, which is exit, and enhanced exit. Exit relates to this idea of leaving the employment relationship. And we contend that exit is not an appropriate Republican strategy to address the problems of domination of platform workers. Exit someone's job should not be a real solution for the structural problem that platform work is creating. And even the enhanced exit version, which underpins social security and eases the transition of platform workers from one job to another, shouldn't also be seen as a viable Republican strategy. This is simply because if platform workers leave one job, they probably just fall into another job that is structurally problematic. In other words, there's domination in one job, and then you switch to another job just to find more domination. So then we turn into the constitutional rights strategy. And the constitutional rights strategy is perhaps more promising as it focuses on taming private and public power. And this is one of the virtues of republicanism as a theoretical foundation of platform workers' collective voice. There's a focus not just on what public power does, but also on what private power does. And as we know, platform companies have proven to have lots of private power based on market power. However, the constitutional rights strategy demands to balance, certain rights. And if we consider, for example, collective voice as a fundamental right, collective labor rights in general as fundamental rights, we are forced to balance these rights with other rights existing in society, such as property rights, for example, of the platform companies, and property rights in general, and of course, the laws of the contract. This is an interesting approach, we believe, but this is still problematic because balancing rights may endanger the protection of platform workers' collective voice. So we then move to the third strategy, which is the radical approach strategy, advocated by scholars like Alex Gurevich. He's, let's say, a radical Republican. And the radical approach strategy focuses on social inequalities. Okay, this approach acknowledges that there's a structural problem and there's also an individual problem. And this idea relates to what we just discussed about dyadic and structural market domination. And we focus, or we think it's important to focus on structures because there's economic structures and there are also economic structures, economic and political structures. And both are reified into legal institutions of property and contract. And this is a big setback, a real problem for platform workers. Just to give you an example, the binary divide between workers and self-employed can be seen as an institution of exclusion of platform workers. So platform workers, in theory, have access to a contract of services, but this contract of services does not necessarily lead to be deemed workers. And by not being deemed workers, they are excluded, usually, from very valuable tools, such as collective labor rights, collective bargaining and strike. So platform workers find themselves dominated, not just by platforms, but also by structures, and structures are economic, political, and normative. So we think the radical approach strategy provides a moral justification for platform workers to resist the structures, the economic, political, and legal structures. And we give examples of this in our contribution. For example, we show examples of social dialogue happening outside the norms. There's this case in Korea where platform workers engage in social dialogue with the government and platforms, despite platform workers not being able to engage in collective bargaining, for instance. There are also more classic examples of radical approach or the radical strategy, right? For example, wildcat strikes, or let's say mass disconnections in certain hotspots. Something we were discussing yesterday with Uma and the others. Also forms of protest at different levels of the supply chain, coordinated actions, for example, for platform workers and workers in food chains. So all of these are not so very noble, yet very valuable tools for platform workers to contest the power of, again, platforms and structures, regardless of not being able to do this. And this is important. These actions of platform workers are not enabled by platform companies, of course not, but they're not also enabled by the laws. And this is why this is a more radical strategy. This radical strategy also leads to interesting, unexpected results. For example, in the case of wildcat strikes, it has been reported that some workers, if they want to strike, they have to ask for permission to strike. But since platform workers are not deemed workers, but self-employed, it is a lot easier for platform workers to exercise their voice because they don't have to ask for permission to go on strike against a platform. So this is a good example of how the labor market is changing and how we should look for new theoretical foundations to underpin collective voice, in this case of platform workers. And by the end of our contribution, we also talk about what impact should platform work have on law and worker voice. So we outline 3 ways for theoretical rupture. Okay. Again, there's a need to find, at least for us, a need to find theoretical foundations for platform workers' collective voice to overcome this structural and individual domination. And we contend that the first way is to question the future of contract. Again, as we discussed yesterday, the role of the contract is key in certain jurisdictions, and a Republican approach based on domination may help us understand that the contract of work should be overcome to look at the reality of the employment relationship, and especially to look at the power dynamics between platform workers, platform companies, but beyond that, between platform workers and normative structures enabling or disabling collective voice. There's also republicanism as a theoretical foundation is also important to look again at the relationship between labor law and other subjects. For example, the relationship between labor law and competition law in the European Union has been very, very problematic. Competition law has been squeezing collective labor rights in the EU for quite some time. And republicanism, again, might help us to look at this relationship with other lenses than what labor law has traditionally offered. There's also, again, a relationship of power and domination between labor law and capitalism. And we also think a Republican approach may help to better understand this relationship. And finally, and perhaps most importantly, we think that a Republican focus on domination might help us understand that we have to, or we can, learn from non-regulated associating experiences. We think that a focus on power and domination through the Republican lenses may help us value, the radical approaches of platform workers when exercising their voice. There's a lot of merit on what platform workers are doing, despite their doing so many times out of the law. And we think the way the law can capture and value these efforts is through a focus on, again, power and domination through the lenses of republicanism. Thank you. I don't know, Alan, if you want to say something about our contribution.
I think you've covered that beautifully, Ricardo. So I think I'm happy to kind of join in the general discussion, but yeah, nothing to add to that. Thank you.
Okay, fantastic. Well, thank you so much.
Thank you so much for your interesting contribution. I'm sure we'll have a lot of reflections on your paper. And at the end, and without further ado, we go to the second contribution that is coming from Professor Paul Scoukens, Dr. Alberto Barrio, and Dr. Eleni De Baker, that focuses on the problems that platform workers face in relation to their social security rights and how these issues can contribute to in-work poverty. Alberto, I think you have the floor. Thank you so much.
Perfect. Thank you very much, Harry. And thank you very much for inviting me for this presentation. I hope that everybody can hear me well. Okay, so I would like to first, so as Harry was saying, this is a contribution that we drafted. This is a raw draft, of course, and we are very much looking forward to your opinion. So the contribution starts from the point that, as you may know, in-work poverty is on the rise on the European Union. Since 2006, it has raised quite considerably from an 8% to now an 9.4%. And there is quite a lot of concern both at national level and in the European Union. And this has been reflected, among other things, in one of the principles of the European pillar of social rights being focused on in-work poverty, and as well as several measures both at national level, such as establishing minimum income, and at EU level. One of these measures has been the Council recommendation on access to social protections for all workers and the self-employed, which is, of course, not exclusively focused on in-work poverty, but that was, in my opinion, and also as seen in the text of the recommendation, one of the reasons behind it. So what we do in this contribution is to analyze how social security systems may not be adapted to platform work, starting from previous research on how social security how non-standard work fit into social security systems, and then we use the Council recommendation on in order to see these challenges, because actually the challenges that we have identified fit quite well with the principles of the Council recommendation on ensuring effective, formal, and adequate access to social security. And then we finally we end the contribution with some ideas for further research. So without further ado, I will start. So as I was mentioning, social security in-work poverty on the rise is quite a concern, and we have observed also by other researchers in previous research how in-work poverty is particularly a challenge for persons in non-standard forms of work. This is so in part because, of course, the active labor market policies are pushing people into work, but the work it's increasingly more precarious, as we have already analyzed in this in previous contributions during these presentations. Non-standard work, as I was mentioning, increases the risk of in-work poverty, among other reasons, because persons in non-standard work are often excluded either formally or effectively from social security protection, at least from labor-related contributory social security protection. So first of all, we believe that we needed to define what is non-standard work and platform work, because the features of these forms of work and actually how they diverge from the features of the standard employment relationship are key for later on not having social security protection. So in some cases, so in the case of non-standard work, well, we define it, of course, as a deviation of the standard employment relationship, defined as stable, open-ended, and direct arrangement between dependent full-time employees and their unitary employer. This is a definition made by Walton, but actually based on definitions made by Catherine Stone and others. And so, as I was saying, non-standard work is formed to deviate from that. That can be part-time workers, that can be fixed-term workers, that can be, of course, self-employed person, and other forms of flexible employment relationships. And platform work, it's then, well, I'm not going to go in detail on the definition of platform work, of course, because here everybody knows it. But some of the elements that we highlight in the contribution are the fact that the platform possesses essential information about the relationship, which is, of course, not always the case in all forms of platform work, but on those that we focus is particularly the case. There is a monopoly over the contact between the two parties. Well, other elements that may be interpreted as control is the fact that the platform provides rules concerning the behavior of both parties and may sanction the lack of compliance. But a key element, at least in our opinion, for social security it's the reduction of the barriers for access to employment that platform work allows. So now through platform work, it's much easier to access to the performance of self-employment or very, very extremely part-time work arrangements in a way that it wasn't as easy before. And that has been a challenge for social security systems and for individuals, as I will analyze later on. So concerning challenges for social security, as I was mentioning before, so the main issue that we observe is that social security systems have been designed around the standard employment relationship. And this is the case both in every, this is the case in every type of social security system in Europe, at least, either Bismarckian, universalistic systems. So in all these systems, we see at least in some degree a dependence on work to define the personal scope of social security schemes and to define the rights and obligations. Of course, this dependence varies a lot between the different kind of systems. Universalistic systems, of course, they have less dependence on the performance of work to define rights. Weberigian systems as well, but in all systems we see a certain dependence. And of course, universalistic systems have other issues as well as Weberigian systems. Some of the issues of universalistic systems that we are seeing more and more is the requirement of residence in order to define rights, which is of course something that it's becoming more challenging in a society in which mobility is more and more common. But we don't go a lot in depth into that issue. So overall, there are two main issues for access to platform workers very broadly. One is the formal exclusion. Well, three main issues: formal exclusion, effective exclusion, transparency, which is actually an issue that goes every aspect of the social security protection platform workers. Concerning the formal exclusion, traditionally, person that has been classified as self-employed workers has been excluded from many social security schemes. So that's, of course, a challenge for platform workers, something that in some cases has been changing, particularly during the COVID pandemic, in which at least temporarily the scope of some social security schemes, more importantly, unemployment schemes, has been broadened slightly. But this is still an issue in many countries, such as, for example, Germany or the Netherlands, in which persons who are considered self-employed, or at least the traditional conception of self-employment, they are excluded from the scope of social security schemes, such as, for example, unemployment, labor accidents insurance, or even in some cases, old age pensions. Another challenge in formal exclusion is the exclusion in several countries of forms of work that are considered of marginal importance or not performed in a professional manner. And this is particularly an issue with situations of platform work because of the potentially very few hours that platform work may be performed. Of course, there is a lot of variety between situations of platform work, but the technology allows a person and also the arrangement between platforms and workers typically allows situations in which a person may perform a few hours of platform work within a period of a month or even a year, or may of course perform platform work in a full-time basis. There is a lot of variety. But in cases in which very few hours are performed, those situations might be considered in many national systems as situations of non-work, of non-professional work, either because it's not performed on a regular basis and therefore is not considered as self-employment in many countries, as for example the case in Spain, or in the case of employment relationship, even if the situation will have been considered as an employment relationship, there are some countries that exclude from corporate situations under a certain threshold. This is of earnings. This is the case, for example, in the UK. And in Germany, there is the work arrangement of mini jobs, marginal jobs, that allow for the performance of work in an employment relationship without being covered by most social security schemes if work is performed with providing earnings of less than 450 euros a month or with an overall duration of less than 70 days a year. Very broadly said, I can go into detail on this in the questions if you would like me to. But the conclusion is that there are many forms of performance of work, actually, of platform work, that could be excluded from formal social security coverage at national level in the EU and EU countries. And there is also, of course, the effective formal exclusion, which is resulting from the requirements of having performed work over a certain period or having provided contributions. Usually it's linked because work, at least in employment relationship, is linked to periods of contributions of a certain amount or a certain period. And these requirements we observe that in many cases exclude persons who perform platform work who struggle to fulfill these requirements. And this is in part because, as I was saying, the few hours that potentially platform workers may perform, but also the difficulties in measuring that number of hours. We see how well, and I think that this has also mentioned in some of the contributions, it's not always easy to determine when exactly a platform worker is performing work, of course, unless you have the data from the platforms, but from the platform worker's perspective, it's not always easy, particularly consider waiting times. And another challenge that, and by the way, one initiative that I think was very interesting mentioned yesterday, that we don't introduce in the contributions that perhaps we made, we should, it's this initiative by trade unions of measuring the working time from the side of the employee. So through, for example, apps, I think that that could be an interesting perspective also for social security. Another challenging aspect is the fact that it's not always easy to identify the employer for social security purposes. This is particularly so in the case of applying the coordination regulations on social security that apply to mobile platform workers in the EU, but it's also it may be also a challenge at national level. We haven't seen that many challenges on this yet, but it could be, because sometimes it's not clear whether the employer may be the office that established the algorithm. Sometimes in other countries, where the offices are based, the human resources offices, or even the direct client that the person performs work for through the platform. And then, so now I would like to move on quickly to the Council recommendation that I was saying, in our opinion, summarize quite well these challenges and establish some form of normative framework to address them. So perhaps not surprisingly, the Council recommendation, because it focuses on challenges of security for concerning non-standard work, it establishes these three principles, which is formal access, effective access, and transparent coverage. Concerning, I will not go too much into detail concerning the first two. I will go briefly, but just to make sure. Second, perfect. So concerning formal access, well, first of all, before going into these three aspects, I would like to say a few words on the Council recommendation and particularly its scope. The Council recommendation, as I was mentioning before, resulted from one of the principles of the European Social Pillar, particularly Principle 12, and it was it was quite a difficult measure to instrument to approve. Originally was supposed to be a directive, and that was how it was negotiated with social partners. But eventually, also concerning discussions on the competencies of the EU, it resulted in a Council recommendation, which, as you know, it's not legally binding, but of course it's a legal instrument, and it's actually the legal instrument under EU law that it's the most clear on social security harmonization, which is of course always a topic of debate of whether or not the EU should or can even do social security harmonization. Social security, as you know, is typically a competence of member states, but under certain circumstances, the EU may, or at least, or is even the question if it should do social security harmonization. So concerning the Council recommendation, even though it's quite careful in what it harmonizes, there is clear recommendations on particularly on formal access. Well, formal, effective, and adequate, as well as transparent access. But with formal access, perhaps is the most shocking because it's the first instrument that clearly says that formal coverage concerning the contingencies that the recommendation covers that are labor-related contingencies, such as unemployment, labor accidents, and so on, that formal access should be ensured for both employees and self-employed persons, no matter the kind of employment relationship or self-employment relationship that it is. In the case of self-employed persons, there is a clarification. The and in part related with the concerned member states, that says that at least will be done in a voluntary basis and when appropriate in a compulsory basis. In the case of employees, formal coverage will be given always in a compulsory basis. This is something quite strong and new because, as I was saying before, in most member states, formal coverage concerning self-employed persons is not granted in many cases. So a legal instrument of the EU that says something like this, even if it's not binding, is quite important, at least for people like us that have been researching EU social security law for a while. So that's something that it needs to be taken into account. Concerning the material scope, there are many criticisms that can be made on the Council recommendation. The personal scope is not very clear. There is no definitions of worker or self-employed, and a clear definitions, at least under the recommendation that used to be before. Now it's very broad definitions that it's not clear if they are based under EU law or the definitions at the national level. Concerning material scope, one of the things that can be said of the recommendation is that it's not clear that there is an acknowledgement of the interconnections between social security schemes and contingencies. Family benefits are not covered under the scope of the Council recommendation, which can be a challenge, particularly in order to fight in-work poverty, because in many cases, the household composition has an impact, of course, in non-standard workers and particularly platform workers. A person that needs to perform many hours of work on a very flexible basis without stability and has, of course, family responsibilities, have different needs than a person that hasn't, and that hasn't been addressed in the Council recommendation, and we believe is something that needs to be addressed clearly, also at least at national level and hopefully at the EU level as well. Other things that I perhaps should highlight, I will move on now because I see that I am in the last minutes of presentation, to transparent coverage, because it's something that I haven't addressed before. But I think that it's also where the topic of discussion, particularly I believe in the labor law field, but also important the social security field, has been focused until now, which is the lack of clarity on employment status of platform workers, which of course extend to lack of clarity and lack of certainty on what their social security rights are, because there are in most countries no specific regulations on the social security rights and obligations of platform workers, with the exception of mostly France. We have a specific social security provisions of platform work, but only concerning labor accidents and professional diseases, and only for those that have been classified as self-employed platform workers. Other countries like Spain and Italy have some regulations on the employment status, but in most countries there are no specific regulations on platform work. So we depend on the application of the traditional legal framework, and we see how challenging that application is because there is no clarity on employment status. All these challenges on what's the employment status of platform workers are particularly concerning for social security, because we need social security since they need to plan for the long term, and changes also may apply retroactively. Employment status determine rights and obligations of persons that maybe are only applicable 10 years, 15 years from now. And so when an employment status changes, it's not just the changes that affects right now, but also changes that may affect much later on. Sometimes people may not even realize that the importance and relevance of those changes until many years later, when they may need to resort to periods of insurance, and that it's not clear may have been performed under a situation of employment or self-employment, and that's particularly challenging for social security. So transparency, it's an aspect that I think that should be paid a lot of attention in the field of social security and platform work. The Council recommendation introduced provisions on that, but it seems that those provisions haven't been the focus of attention as much as concerning others. This is something that I believe that for the future of research on social security and platform work really should be paid attention, and also on the simplification of social security systems for persons in situation of platform work. Traditionally, persons in situation of self-employment may be aware of requirements on requirements concerning social security because they were professional self-employed persons. They were persons who intended to perform an activity as professional self-employed and had at least some training and know how to on what they have to do in order to fulfill their obligations. But this is not always the case concerning platform workers. And this is in part because of this reduction of barriers that facilitate access to self-employment in some cases to, well, again, the discussion of whether they are self-employed or employees, but right now in most countries, platforms consider them as self-employed. So I will start with that basis. And platforms facilitate access to self-employment very much, sometimes to people who are very much not aware of the requirements that they have to fulfill concerning the social security obligations. They only became aware of them much later. Just to give an example, in the case of Spain, research by trade unions have proved that platforms, they immediately, like when a person goes to the interview to get hired for a platform as a platform rider, for example, they immediately transfer them towards a second company that do all the requirements concerning social security. It's in theory an external company, but I mean, well, at least that's what they say. And then these companies, they not always inform them, or it's not always clear for the platform worker that only during the first year they will have a reduced social security contribution, but after the first year, that social security contribution will be raised a lot. It will pass from approximately 50 euros per month to more than 400 euros per month. And that's the minimum contribution. And that's not something that, for example, platform workers that are self-employed persons may not be aware. Many of them are migrants, and it's something that a traditional self-employed person typically is aware because they have to, because they are the ones who are responsible to apply for these things. But in the case of platform work, many times platforms have facilitated these requirements very much, but then persons are victims of this lack of information. So I believe that my time is out. I have tried to highlight some of the aspects that we believe that are interesting for research, also research that we have done. Maybe a couple of others. I mean, one of others is sustainability, one that I remember that was mentioned yesterday, but for social security, which is to balance rights, to ensure adequate rights of social security platform workers, together with the sustainability of the system, the financing of the system. And that may be linked to changes in how we finance social security systems, perhaps linked to more taxes focused in those companies that take advantage of the system the most. So with this, I would like to end my presentation. Thank you very much for listening to me.
Thank you so much, Alberto. Thank you so much for your clear presentation and important contribution. And I'm sure you will have time to have more reflections during the general discussion. And now we move on to our final contribution by Nastazja Potocka-Sionek, that she focuses on the regulatory framework for crowdwork through the lens of global supply chains. Nastazja, you have the floor. Thank you.
Thank you very much. So let me first share the slides, if it works. I'm not sure if I can do that, actually. Yes, I'm getting there. Sorry. Now I think you should be able to see them. Does it work?
Yeah, perfect.
Yeah?
Yeah.
Okay. Great. So thanks so much, first of all, for giving me this chance to present here and to contribute with the chapter. The working title of the presentation is Towards a Regulatory Framework for Crowdwork, the Lens of Global Supply Chains. And I look at the crowdwork platforms narrowly defined, so mostly those that fragment work into small units and outsource them and outsource these minor tasks to an open pool of crowd workers. And here we can think mostly of the microwork platforms such as Amazon Mechanical Turk or the Crowd Guru. But also, I think it's worth to bring those creative crowdwork platforms or even competitive programming platforms into the picture. And my approach is normative and comparative one. I think despite the vast heterogeneity of platform business models, some underlying processes such as transnational fragmentation of production, the commodification of work, and the managing of workflow of remote workers, these are underlying issues that are posing serious governance challenges to the effective regulation of this kind of work process. But these are by no means new issues. They have been long present in the context of global supply chains, for example. That's why I'm taking this comparative lens for my analysis. And yesterday we've heard an excellent presentation highlighting the spatial dynamics of digital labor platforms, and it also elucidated how various patterns of economic activities create really the governance gaps and eventually impact the individual working situation of crowd workers. So this is yet another very compelling parallel I think we can draw between the crowdwork platforms and global supply chains. So my stance, as I already mentioned, is very normative. The key question I grapple with is how to ensure that labor standards are respected in the platform-centered ecosystem. But I think that, and how I approach this question is through referring back to another question that regulators were struggling with for a couple of decades now, namely how to make lead firms liable for adverse effects of their transnational operations. And I'm not arguing that these issues are identical or that we are able to replicate the responses that were taken, that were put in place in the global supply chains context, neither that this would be desirable, but I think there still are a couple of lessons to draw from what has been developed as a regulatory framework for the GSCs. And before that, that normative mapping exercise as well of the regulatory landscape, I need to give more context on the power relations, on the labor standards, and on governance challenges in both respective models of industrial organization. And firstly, looking at crowdwork, as we are all aware of, one of the core issues with regulation of crowdwork platforms is that they almost invariably present themselves as this non-hierarchical marketplace, as a peer structure. They deny any form of explicit coordination or control over the working process. So they also shield themselves from employment liabilities. And also the important difference, I think, between crowdwork platforms and on-location ones is that indeed the direct impact on working conditions is exerted to a lesser extent, because it's the clients that often determine the working conditions, the time frame, the pay rate. Nevertheless, crowdwork platforms such as Amazon Mechanical Turk, they are the center of the multi-sided infrastructure, and they dictate the conditions of inclusion, exclusion. They dictate all the patterns of behavior of respective parties. So apart from just this nominal shifting of responsibilities onto the individual contractors, I think, and the employment status questions that we were discussing at length yesterday, I think there is more to regulatory challenges in this sense that the design features are really a root cause of labor rights deficits, and the fact that they indirectly impact working conditions, for example, by exerting pressure on them to have as high ratings as possible. They also extend the working hours, for example. Referring back to the labor geography that we learned about yesterday, the massive oversupply of workers, for example, from global south mainly, also impacts or influences the pay rates and the race to the bottom in working conditions. So this whole interrelation of issues translates into huge governance gaps. Both on the level of enforcement, because, for example, the crowd workers will be faced with the difficulty of finding a relative counterparty to the dispute. Also, there are jurisdictional questions there behind. So the extraterritorial aspect of crowd workers' operations is a very, very big regulatory gap and regulatory loophole. But as I argue, these issues are a continuation or an exacerbation of the challenges that we saw and continue to see in the global supply chains context. Because also there the lead firms do not exert direct influence on the operation of their suppliers and sub-suppliers, but they outsource the legal responsibility. They not only outsource the very production process, but also the liability for working conditions. And nevertheless, despite their lack of direct influence, their practices, such as predatory purchasing practices, they exert the pressure on suppliers, which in turn translate into poor working conditions at the downstream of their chains. What it can lead to, we saw with the dramatic collapse of Rana Plaza factory back in 2013. The picture of it is here at the back of the slide. So, and also this tragedy actually showed us how difficult later on it is to bring the global buyers into some compliance and into liability for the impact of their transnational operations. There are some governance gaps that are fairly similar, also with the extraterritorial dimension of their operations, with jurisdiction and the very fact that it's for the host states in principle to ensure that human and racial rights are respected on their territory. But the problem with that is that often there are states with deficient governance structures, and they have very scarce power over the foreign-based companies. And we could, of course, discuss much more in detail about all these parallels, but also very notable differences between both models of business organization. I think that the core takeaway of this is to see platforms and lead firms as key actors in their ecosystems. In both cases, we see this coordination and control, of course, to varied levels. But also it's interesting, I think, to bring up that the global supply chains and the platform ecosystems, they are both kind of hybrid structures between market and hierarchy. So also in GSCs, global buyers not always have this linear value governance model, but rather there are some network structures as well. So there are nevertheless indirect influences that they exert on working conditions at the downstreams of their production chains, and despite that there is no liability for labor rights and human rights. And with that in mind, we can proceed to the mapping of the changing legal landscape. So which mechanisms are currently in place to respond to those governance challenges? And starting with crowd work, if I were to summarize the landscape with one statement, it would probably be that it's an uncharted territory, but not a legal vacuum. So on the one hand, there is lack of any specific instruments that address particularly those crowd work platforms operating globally. Neither on the national level, nor at the European one, and also international one. However, it cannot be said that there are no instruments that encompass, that cover those work constellations. Because on the international level, we have the various soft law instruments. First of all, there is the International Human Rights Due Diligence Framework. So starting with the United Nations Guiding Principles, which anchor the due diligence concept. And digital platforms are covered by it, much as any other multinational company. And they are, in principle, obliged to respect those or to ensure that their operations do not violate the human rights and labor rights as well. There are also other soft law instruments such as OECD guidelines or the ILO tripartite declaration on multinational companies. Moreover, some of the core principles and rights at work at the ILO level conventions also apply. There are other standards mentioned as a part of the Future of Work initiative in 2019, and it's highlighted as grey because it's just an initiative, but there are no concrete steps undertaking, to the best of my knowledge, to translate it into concrete action as yet. And apart from these soft law mechanisms, private governance instruments are flourishing right now. Instruments, and they are very vague in their nature. Plus, there is a growing number of multi-stakeholder initiatives, the prime example of which is FWO Foundation. These are, of course, very valid one and definitely worth taking into consideration, but later on we will address some of the limitations of these. And now stepping back to see how what kind of mechanisms are there to govern global supply chains, we see that the map is somehow fuller. Starting again with international level, there are the same instruments that I just referred to above. Also, the private governance mechanisms are more developed because apart from the codes of conduct, there are such schemes as social auditing or certification schemes, also reporting systems that try to harden, let's say, the only voluntary codes of conduct, but still the nearly 25 years of experience with this kind of private-only mechanisms show that there is no power really to exert the sustainable change of corporate behavior only by these means. There are also multi-stakeholder initiatives as well as the international framework agreements. And there is, for example, no counterpart, I would say, of the international framework agreements in the crowdwork context. But what I want to highlight here is that at the national level, there are a number of important developments to regulate global supply chains. And there are very broadly two groups of these. So firstly, the first wave of regulation of global supply chains is the disclosure legislation only, such as the UK Modern Slavery Act. These do not implement any mandatory human rights due diligence standards. And they have also turned out to be too weak a mechanism really to bring sustainable change. On the other hand, we see a growing number of mandatory due diligence laws, starting with French duty of vigilance law 4 years ago. But also the next slide shows that there is really a marked shift towards mandatory human rights due diligence on every level. So on the international level, there is the initiative, the UN initiative towards legally binding instruments to regulate international human rights. It is still being developed, and there is now the second draft of such a instruments. So let's see if this is able to overcome the intrinsic limitations of the soft law nature of human rights due diligence framework. Also, there is an EU legislative initiative on mandatory human rights and environmental due diligence, as expected end of this year as well. And at the national level, again, there is supply chain law in Germany and also Transparency Act in Norway. They all are say shift or an intention to harden the existing framework. In the crowdwork context, there is no such shift yet, I would say. And the first point I'm making here out of this comparison is that it's worth to highlight the states as, or the centrality of this harder approach to regulating transnational companies, and that it's difficult, but it's not impossible. And very briefly, I suggest in the chapter 4 ways forward. The first one is again coming back to the employment status. So it would be the most immediate answer of laborers hold crowdwork platforms as employers. And this is not because last year the German court has held one of the microwork platforms, Romler, as employer of micro workers. So this is also a positive sign that that we shouldn't draw this very sharp line between on-demand platforms, which can possibly be held employers, and crowdwork platforms. As we shouldn't straightforwardly exclude this option, but it's very highly doubtful if this will consolidate as an approach, and there will be still crowdwork platforms which will not be held employers because of the too tacit and too indirect influence, for example, on the working conditions. But still, it doesn't mean that these crowd workers should be excluded from the protection of their rights. So I think we need to look for further options. And one of the paths is corporate social responsibility. As highlighted before, we have already such mechanisms, and there will be very likely more to come. However, it is still not enough, I would say, to really improve substantially the working conditions because of the soft law, voluntary nature of it. Then we could continue thinking about the international governance framework, given the extraterritorial challenges to implement some regulations on the national level. And here, referring back to the Global Commission's on the Future of Work proposal of international governance framework, there are existing soft law instruments as well. But again, learning from the global supply chains experiences, I think it is equally important to have this international governance framework as to also think of the other levels, so the multi-level responses needed. And then the last point is transparency and disclosure regulations, digital rights, and as I say, and beyond. Because here I have, there's a lot of things going on in the ambit of transparency of algorithmic management and how to ensure digital rights of workers. These are instrumental, really, to implement and to put in place labor standards and labor rights. But I think that only by focusing on this transparency and on digital regulations, we risk forgetting about the labor mechanisms, let's say, that we have, and the labor rights as such. And there is much more to make out of the data accumulation power that platforms have. I think that that this data accumulation is a double-edged sword in a way, that if left unregulated, there are considerable power imbalances. Workers are dependent on platform ratings, on algorithms. There is lack of transparency. But we could actually mobilize the fact that platforms exercise this oversight over the entire work process, and they could be held accountable for the implementation of some employment rights, for example, and employment regulations. So the question for regulators is how to mobilize this potential and how to make platforms improve the regulatory oversight. And I conclude, I'm aware of time limitations, so here very briefly only, I think that there is need for state-based regulations, also in the realm of crowdwork and this multi-level response. Also, both private and public regulations should be put in place. And there is space for stronger forms of corporate obligations, and there is need to go beyond this algorithmic transparency. And I know it sounds very ambitiously, but I think that these are some sources of inspirations to work and to reflect on further. So thank you very much for attention, and I look forward to feedback. Thank you so much.
Thank you so much. I think that was one of the best ways to finish with our contributions with a subject and a comparative analysis that, at least according to my knowledge, has been underexplored. And I would like to open the floor for clarification questions and reflections, of course. And I can see Christina.
Yes. Thank you very much. And I just wanted to reflect a little bit on this last presentation, because I think it was brilliant, and I think it's a very important area of study that it's right has been under discussed to some extent. And I wanted to say that while I'm working on a different project now that is on gang masterings and exploitation of workers in agriculture. And that led me to try to see a little bit more the case law on gang mastering. And this year, a really interesting decision was taken by the Milan Tribunal about the use of basically gang mastering methods for Uber Eats. And actually that led me to understand a little bit more like the corporate structure of Uber. And I think I always consider the fact that they rely a lot in subcontracting, and for the recruitment of workers, they rely on cooperatives that are like sham cooperatives or bogus cooperatives that actually goes in migrant hotspots to recruit migrant workers to work in the gig economy. And I think that is a big issue, because while there's a huge attention in anti-trafficking, gang mastering, like decent work, human rights, in some of the sector and in the global value chain literature, this has not been very much connected with the gig economy discourse, but it is very much interconnected. And actually we are seeing that the same dynamics are going to be put in place. So I think this is very important. One of the points that I think it might be worth considering is that it's not only about the discussion about regulation and possible regulatory solutions, I think in Italy came out because of criminal persecution. So there is a strong connection with criminal law and the human rights aspect and labor law. But without that dimension, the framework would be a little bit incomplete. And actually, it is very difficult to implement forms of control as well. One of the other cases, big cases that came out in Italy, as again on the topic, which does not affect like gig economy, but is about like farm sector, was actually making very clear that the controls that the global value chain regulation, the self-regulation of the chains and the companies, like the huge company that subcontract work, is not effective because the inspection are actually bogus, or they're programmed so they can.
Sorry, I'm intervening because we're running out of time. If we can just keep our comments a bit shorter. I'm really sorry.
Yeah, no, it was just a connection. So I just wanted to thank Nastazja for the presentation and ask if like the criminal dimension could be put there somewhere as well. Thank you very much.
Thank you. Nastazja, do you want to reflect now? Or should we get more questions maybe, or it's up to you?
I don't have much of a big comment for what Christina said. Definitely, I mean, this criminal aspects, and you know, it's all interrelated in a way, and it's good to see. And here I focused on crowd work on these global web-based platforms, but actually those on-demand platforms, so Uber, they are also transnational, right? And some of the corporate business issues are very much interrelated. So I think that we can you know, start a new project, a new study on that, on how to put those things together.
Okay, thank you. Professor Dukes, you want to add something?
Thank you. 3 great papers. I've really enjoyed them. Ricardo, I thought you presented very well. I also enjoyed your contributions earlier in the morning. If I may, though, I'm going to push you a little bit on being a bit more precise about what's new about what you draw from Republican theory. Alvin and I have had this chat in the past. But you know, you make the claim for new theoretical foundations. I had in mind Cynthia Eslin's excellent review of Elizabeth Anderson's Private Government that I read recently, where Cindy points out that Elizabeth Anderson begins by saying kind of, no one's really written about this before, so I'm going to make this really new contribution. And Cindy's gently and respectfully saying, I think we have, you know, I think a lot of us have thought about this stuff before. And similarly, Alex Gurovich's article on our radical right to strike, exactly the same. He starts by saying, no one's really written on the right to strike before, really. So, okay, it's new for them, right? This may be new in political science. It's not new for labor law. It's not new for industrial relations. So what do you think they're saying that industrial relations scholars or labor law scholars haven't already said?
Okay, Ricardo, maybe you want to reply now. And
Alan, would you like to say something? Or
yeah, I'm happy to address that. I think it's a great question, Ruth. And I think what I would say is that in many ways, the kind of turn to republicanism, which has become very popular in the labour law field, there's now a kind of steady stream of papers that are kind of trying to reposition labour law around Philip Pettit's work on non-domination. I'm actually sympathetic to your position and to the position of Cindy Eslin, which is to say, actually, I don't think there's anything deeply insightful in this body of work. I think it's, you know, if you were to look at the work being done on labour law over the last 100 years and you went back into the historical texts, a lot of the same claims were made, but in a different idiom. So, you know, to go back to an absolute classic in the kind of British IR tradition, Alan Flanders, collective bargaining, a theoretical defence. He doesn't use the terminology of non-domination, but that's exactly what he's doing when he justifies collective bargaining. I think what I would say is that it needs to be engaged with because it's become so popular as a paradigm. And in fact, I'm rather cautious about it because I think there is a tilt in that framework towards deregulation. So that's why we kind of take on the exit is enough position, because actually that's very central to the political theory work being done in the Republican tradition at the moment. So to put that in the center of our piece isn't to say, oh, this is radical and we've never thought of this before. It's actually a more defensive theoretical move, which is to say we need to be careful about what we buy into, because this tradition I think does have some interesting things to say, but also I think is potentially a dangerous supplement when Labour lawyers swallow political theory whole without reflecting on what the kind of regulatory implications are.
Can I comment on what Alan was saying?
Yeah.
I think this is well, we share the same probably arguments on this, but I also like to think that republicanism has or provides a practical explanation for a very old problem of labor law that is exacerbated in platform work, which is a problem of regulation. Every time we discuss platform work, we tend to think of it in terms of regulation or fit into a category, and that's all fine. But there's also a much deeper concern on how can we tame the platform economy without chasing for further regulation all the time. And I think republicanism offers a broad perspective, and not to say this is original from republicanism, it's actually a tradition of many other traditions, but it keeps you aware that workers have a lot to say on this. And this is why we emphasize the radical approach, because in platform work, if we trust workers' organization, we wouldn't have to rely so much on the constitutional normative infrastructure that labor lawyers are so used to build in order to protect workers, if that makes sense. But in no way we're saying republicanism is new, but I think it does provide a nice framework to understand what I was just saying about worker mobilization and the role of laws in general.
Okay, thank you very much. Can I ask you something on this? So when you presented these three different normative approaches, I saw that you did it like in a kind of separate way. Does this mean automatically that one approach automatically actually excludes the other approach? Because maybe we can also have a combination of a radical approach and a constitutional rights approach. I mean, trade unions, we have examples of trade unions, both bringing cases in the courts and also going on wildcat strikes. And last question, like on this as well, do you also think that the constitutional rights approach, for instance, is more difficult to be applied within a UK context, where yesterday we also saw that the courts pay much more attention, for instance, on substitution clauses and not so much on the primacy of facts. So maybe the constitutional rights approach can have maybe a different application in other legal contexts, except of the UK, from the UK. That was my...
Alan will be anxious to answer this question.
Yeah, so thank you for that. I think it's a great question, Harry. You seem to have frozen, or maybe you're just you always sit like that. Can you hear? Can you hear us?
Yeah.
Cool.
Yeah.
Right.
Moving. I'm trying
Excellent.
to move.
So in no way would I think we want to suggest that these are approaches that you take in isolation. I mean, I think what I would say for my own part is that to take any one of those as a silver bullet is a big mistake. So we were very keen to rebut a very strong position in the political theory literature that exit is enough. So that's actually become very prominent as a Republican position. So it isn't quite the same as being committed to labour market deregulation, because there are some interesting proposals around universal basic income and the provision of training grants in order to make exit more substantive as a right, but it certainly may be necessary, but it is not sufficient. And I think really the same is true of the constitutional rights strategy. I think that there is real value in this, but I also think it's important to recognise the limitations of it. So if you take the Uber case, that litigation dragged on for 6 years in the United Kingdom, and the upshot of it from a collective perspective was that Uber then rapidly went into a collective agreement with the GMB, which excluded the IWGB and the ADCU, which were, in many ways much more radical grassroots organisations. So I think the distinction is really to frame them as ideal types, just to clarify what's at stake in each of them. But from a strategic perspective, of course, workers and unions should use what works, and what will work is very context dependent, and it will no doubt involve a blend of all three strategies at different times and with different interactions between them. So it's really a plea for eclecticism in strategic approaches. Yeah.
Nice. Thank you so much. And I think Alberto.
Yes, thank you. It was a very brief question concerning Nastazja's contribution. Just in the part of transparency and data accumulation, I have heard of some initiatives of using GDPR as a way of accessing this data and putting pressure on it on the platforms. I was wondering if you thought of addressing that or not. It was just that question. Thank you.
Thank you, Alberto. So yes, GDPR is an interesting mechanism, I think, to look at also in this context of extraterritorial application. No? So it's a good way of thinking of how to regulate and how to exert the impact or how to bring those platforms that operate transnationally into compliance with the GDPR, at least at the European Union level. But I still think that the transnational GDPR will solve a number of issues. Well, it might be too weak a mechanism, also only in this digital rights ambit right now, looking at the developments of artificial intelligence, right? But I would be more interested in saying how we can exert more from the platforms, so how to bring them into compliance with other labors, or to put it differently, I think that GDPR only can impact the internal aspects of platforms or operation, right? So to manage how their algorithms work and how to make it transparent, how to ensure that workers have access to their data, and to make it all also explainable. But there are still issues with compliance with, for example, minimum wage or the working time and many other employment aspects that this instrument is simply not regulating.
Thank you very much, Nastazja. Professor Bogg, you want to say something like a final comment before I give the floor to Valerio for the reflections and closing remarks?
Yeah, thank you. Just to say, 3 fantastic presentations. It was really great to see them, and I learned so much. It's a very brief kind of comment to Nastazja. So I thought that was a fascinating presentation. One thing I wondered about is the potential role of accessory liability for supply chain regulations. So I think one of the difficulties I've seen in the UK, for example, but other jurisdictions as well, is trying to affix liability on lead companies using something like a joint employer doctrine. Now, the problem is that often lead companies in supply chains aren't operating as employers and aren't performing employer functions. So I think that technique as a regulatory technique is unstable because it's a strained characterization. And I think it's actually much less strained to say that the lead company is an accessory to the primary wrong in the supply chain. And actually accessory liability is a very established part of most legal systems, so that were you intentionally assist or encourage a primary wrongdoer, you become liable as a secondary party. I mean, that form of liability has been in existence in the English legal system for the best part of 200 years. I think part of the problem is it isn't that there aren't techniques available, it's just that lawmakers and enforcement agencies perhaps haven't used what's there. So actually, I've emailed you. I've sent you a piece that I've just recently written on accessory liability in supply chains on national minimum wage violations that might be of interest. But thank you. It was great. Really great presentation.
Indeed. Valerio, you have the floor also for the closing remarks. Thank you.
Well, I think we have still a few minutes, and I wanted to also ask a question. I mean, those were all excellent papers, and I'm really so thankful to all of you. I want to ask a question, if I may, to first to Alberto. Alberto, do you think that what you see and the contribution that platform work have on an implication that it has on income poverty and in work poverty are specific to platform work, or they should be seen more broadly in the context of basically the implication of precarious and stable jobs, bogus self-employment, casual work to in-work poverty? I wonder what you think from your social security perspective on that side. And Alan and Ricardo, I think if I can circle back to the first question that Alan asked yesterday on the personal work approach, one of the things that I come to think about the personal work approach is that since it is not so much focused on subordination and on control, if we look at it on the common law side, and so on all those implied duties that come with the contract of employment, both in common law and civil law, could it be that if we abstract from those dimensions, we could also contribute to better liberate work from authority and hierarchy? My question is, if one of the key elements for protection is normally that you need to be subordinated to someone else, and you need to have be integrated in another organization or being under the control of someone else, then we give probably too much also axiological value to this. And I wonder if it's not the time to move out of this framework towards a more, I mean, we can call it Republican. I completely agree that most of these things were discussed 100 years ago or even more. I mean, Ruth's book shows this, I think, clearly, and even before that, of course, for civil lawyers, that was super clear. But I wanted to hear your opinion about this.
Should I start by answering or the others?
Yeah, I'm still at you can start, yes.
Sorry, because I know that we are short on time, so I'm kind of rushing into it. So just to answer very quickly, I think that there is one specific thing that is characteristic of platform work, which is, as I was mentioning, the ease of access to work. So I think that because it's so easy to access to work, sometimes platform workers can be considered as marginal workers, and also the element of not knowing their rights. And so as a result, they may be excluded from social security coverage, which as a result increases the risk of in-work poverty, because of course, one of the purposes of social security is to protect against in-work poverty. When persons who are working are no longer protected by social security schemes that are supposed to protect them against in-work poverty, then that risk may materialize, because systems are designed on the idea that people who work will be in some way or another protected by social security. So that's specific for platform work, in my opinion, the fact that it's so easy to access work. But I am interested very much into research that point connections with forms of work and older forms of work, such as casual work and so on, because I am wondering if it is really that specific. I know it's much more easier right now to access work than it was before because of technology, but I would love to see other research that show exactly if that's the case or not, and also empirical research. And also, of course, there is combinations of the typical risk of non-standard work. So platform work, just to summarize, have the same risk of in-work poverty typically linked to other forms of non-standard work, such as part-time work, self-employment, and so on, depending, of course, on the variety of platform work. But I think that it does have specific risks, which is how easy it is to access work. But how specific it is, I think it needs to be answered also by other disciplines such as history or empirical research. But that was from our own research what we came across. Thank you very much.
Can I answer Valerio's question, Alan?
Yeah, we could both. I've got something to say to him.
Okay. Yeah, I hope we got enough time. If I understood the question correctly, I think this is right. So there's this personal work approach, and what republicanism does is it forces this relationship of work and strips it out of the labor constraints, and it makes you think or rethink a very old question, right? Is this person free? Is this person free from domination? So in this way, the personal work approach is interesting, but I think that republicanism has the value that it doesn't allow, or it doesn't point to destruct the labor law sphere. It doesn't point to destruct labor law as a discipline, but at the same time, it forces you to think on a much more philosophical level, if that makes any sense. So, for example, the constitutional approach and the radical approach both combine might support the personal work approach for the constitutional dimension, but at the same time, it will welcome new voices and new forms of voice, if that makes sense.
So I'm probably more skeptical about the personal work approach than Ricardo is, and so let me explain why, and I'll be brief. The first is not a fancy theoretical insight, but it's really just to say that in some legal systems, personal work carries with it historical legal baggage. So I think in the English system, and go back into the kind of early English common law, personal work emerged in a way that was very bound up with personal subordination of the servant in a master-servant relation. And I think if you're going to have an approach based upon that now as a legal mechanism administered by courts, I just think that historical background inevitably influences how it will be applied in practice, even when it's not conscious. So one could have the idea that the personal work concept is detached from subordination, but my worry in the English context is that that might not be so easy to operationalize in English courts because of the historical genealogy of personal work. Now, the second point I think is a bit more theoretical, and it's this, that I can readily imagine in gig work contexts, individuals who are highly contractually vulnerable and who have an unfettered substitution clause and use substitutes regularly and work across different platforms. And the worry that I have is a normative one, which is that predominantly personal work is not an effective proxy for contractual disadvantage and vulnerability to exploitation. And that will mean that it specifies a dysfunctional boundary, because there will be individuals who are not engaged in work in a predominantly personal capacity, who are highly precarious and should be within the protected bounds of labour rights. So that's my deeper worry, that I think is more general than my specific jurisdictional worry about the genealogy of personal.
Okay, thank you very much. I think Valerio, you can.
Yes. Thanks a lot for the answer, and I think this is actually going to be extremely useful beyond the field of platform work. I think it's a problem broader than that. It's a problem of casual work, 0 hours contract, and other forms of precarious work. And I think one of the objectives of also this collection is to say that the gig work, platform work doesn't happen in a silo. It's not just an asteroid that is completely isolated from the rest of the labor market. And I think this came out very, very clearly from these 2 days of discussion. I want to thank all of you for these excellent discussions. It was wonderful workshops. Thanks to all of the speakers and to everyone that participated in the discussions throughout these 2 days. Thank you so very much. I think we can stop the recording now, and if you can stick for another 5-10 minutes